Go ahead. Let me welcome the audience or the discussants, the numbers that they may be. To begin with, let me compliment the CLBA for, once again, has been done a number of times in the morning, for organizing this conference. And I think, personally, I feel that this particular session on mergers is extremely timely, as I can share with you, the Commission is in the process of having a look at its regulations once again. As you may be aware that during 2015-16, we amended our regulations twice. Basically, the Commission itself felt that there were inconsistencies, there were in fact shortcomings, and the requirements of a painless combination regime needed certain changes. Well, we made those changes. We are again having a look, and I in fact, before finalizing them, we would be putting them on the public domain for your comments. As you're aware, and I think it's in the program itself, that the Commission till now has looked at nearly 450 plus combination notices, out of which nearly 430 have been approved. 3 went in for phase 2, where in fact the Commission cleared all 3 of them. We haven't blocked any till now, and with certain structural remedies, they too were cleared. Now, I just want to make one thing very clear, that I remember when, of course, the Act is nearly, it came into force in 2009, and well, it was said that though it was enacted in 2002, it actually got its teeth in 2000. 2002 it was enacted, but got its teeth in 2009, but then let's say the merger bite came only in 2011. And it's not even been sort of 6 years, but well, we moved fast, we've learned. And even at that point in time, since I was in the Ministry of Corporate Affairs, and there were issues whether the sections need to be notified and the regulations need to be looked at. I remember there was a lot of back and forth that one was doing with the industry chambers and associations. And finally, of course, after having convinced the industry that, well, we'll try and make the merger control regime as painless, as convenient as possible, keeping in view the Raghavan Committee's recommendations in mind, we went ahead. I may share with you, of course, that recently only we have put the 40 FAQs which have been put on the Commission's website, though they are not guidance notes per se, but then to a great extent they do provide some sort of a guidance. We have one issue which used to take a lot of time earlier, was the issue of confidentiality. I think the last 3 or 4 months we have decided to accept things as they come. Whatever is being filed as confidential, the Commission has been accepting it, saying that in terms for the present, we accept it in terms of these requirements of Section 57. So, for purposes of the section, as and when we need to look at this confidentiality, we'll go by what the section says. Similarly, you may have noticed that on the non-compete side, where there were issues earlier, we are now trying to come out with a guidance note as to what would be a non-compete, what would qualify, and the thinking in the Commission is that in case the filing of non-compete is as per the guidance, then in the order that we issue, we will not touch non-compete, but where we feel that it is not in accordance with the guidelines or the guidance notes, we may say that, well, this is not ancillary to the proposed combination. But the point is that we would not be spending great time on these, because we do understand and appreciate that there's a cost to this time, and of course, in terms of ease of doing business, we need to move ahead. we also do recognize the fact that as we move ahead, there will be more and more merger filings, there will be more complex filings, there will be areas that we've not been looking at previously, they will be tricky. The entire thing of ease of doing business, we've also seen that the PE investments are now, the notices are coming in much larger numbers. So the basic point that I'm trying to say is that in the Commission there is a great understanding and recognition that we need to simplify things and move ahead. Now there's, in fact, there was an item in this, that's something on automation. I may also share with you that we are preparing it's a software, but which says that what is not required to be filed, and if something is required to be filed, then the various steps that you need to go into. So it's something of a do-it-yourself kit, but that doesn't sort of mean, I mean, there'll be a disclaimer, of course, that the software doesn't mean that at the end of the day, the parties can come and say that, well, since we went through this software, we were not clear, we could not, I mean, our understanding was this, so that's the reason we did not file. That, of course, cannot be. But yes, there would be something to facilitate and help in terms of understanding, but also that doesn't mean that you need not come for a pre-filing consultation. Pre-filing consultation, the window is always there for the firms to come and discuss. Having said that, now let me have the pleasure of introducing our guest from overseas, Mr. Johan van Acker, on my immediate left. Mr. Acker is a partner in the Brussels office of Van Biel and Bellis. His practice focuses on EU and Belgian competition law, with particular focus on merger control. He has successfully assisted clients in numerous merger cases before the European Commission and national competition authorities. On the left of Johan is Geert. Geert is a partner in Sherman and Sterling, Brussels. He advises in all areas of EU competition, merger and regulatory law. He is qualified to practice law in Belgium as well as in England and Wales, and holds an LLM in European law. I don't think the two panelists on my right, that's Shweta and Samir, and Raj Shekhar on the extreme left, needs any introduction, except to say that whereas they've been appearing before the Commission, they've been appearing for the Commission as well. Now, we had discussed amongst ourselves as to how to move ahead in this discussion, trying to keep it short and focused and more interactive. There are going to be, what we've worked out is 3 specific questions. Then there are 3 or 4 areas of discussion, because in the Commission, we keep getting these issues raised by the firms time and again. And we thought that if they are discussed amongst the panelists and the audience, probably in the Commission itself, we may have greater clarity and understanding in how to look at them. And in case it's required, we may try and bring about some change in the regulations. These issues which have been raised time and again are acquisition of minority interest. Then is the concept of gun jumping, yet again, which has not been discussed, been raised with the Commission, but probably must have been raised outside, must have been a point of discussion amongst the firms, is appealing merger decisions. And then, yes, something which has been of great interest to the firms, and they've been sort of hammering and badgering us time and again, is on this entire concept of enterprise versus business division that the Commission needs to be looking at while looking at de minimis exemptions. So we have these 4 areas, and I'm going to put these areas to each of the panelists as we decide amongst ourselves. They would speak on them for 4 to 5 minutes, or whatever lesser time they feel comfortable. Once we've discussed those, then we'll discuss the questions and then open it up for question and answers. Now, the first question or the area of discussion is the acquisition of minority interest, and I would open it up first to Shweta, and then take as to how is this being viewed at in the European Union or in other jurisdictions outside India. So Shweta, can I now open the subject for you for your views, acquisition of minority interest. Thank you.
Thank you, sir. Thank you for introducing all of us and setting the tone for this panel. I think to this audience, to explain what the position of the law is might be stating quite the obvious, but just so that I can briefly set the scene, the acquisition of minority shareholdings has been the subject matter of several decisions of the CCI, partly driven out of the interpretation of what is known as Item 1 of the combination regulations. Item 1 of the Schedule 1 of the combination regulations provides that you can acquire less than 25% shareholding, provided there is no acquisition of control. The acquisition is solely for investment purposes and, or in the ordinary course of business. And that, I think, was a Freudian slip in terms of what has plagued the interpretation of this Item 1 in terms of how private practice at least has been asked questions around it. So I think just to break it down, the first part being the acquisition of less than 25%, I think there is quite a lot of clarity now through the decisional practice that the 25% includes entitlement to 25%. It is all sorts of securities or put options or call options or convertible instruments which will give the holder the right to have about 25% shareholding on a fully diluted basis. So I think that part has been put to bed quite well by the Commission through its decisional practice. Coming to the second part, that there is no acquisition of control. Unfortunately, the Competition Act defines control quite circuitously, that control includes controlling the management and affairs of a company. So giving color to the word control was critical, and through its early decisions as far back as 2012, the Commission started elucidating what control means. And the phrase which has sort of now been accepted to some extent is the ability to exercise decisive influence over strategic commercial matters. Now, how does one gain that ability to exercise strategic decisive influence over strategic commercial matters has also sort of been given color by the Commission. So one part is to do with veto rights, where there are veto rights in favor of an investor, which allow the investor to block or cause a deadlock in respect of matters such as business plan, operating plan, budget, key management personnel, as well as lines of business in which the company operates, have in the early decisions been treated as tantamount to at least joint control from the perspective of Competition Act. However, later decisions have made things a bit muddier. This is because the later decisions have included a larger list of rights which the investor may have access to, and there is not always sufficient clarity as to which of those rights would be treated as being more than minority protection, because ultimately this is all in the reign of a minority investment. Given that, I think it would be very welcome if the Commission was, through further decisions, give more guidance in relation to which are the rights, which is a clean list of rights that the minority shareholder can adopt in its acquisitions, because that certainty and clarity would really help for the ease of doing business in India. And that's something that we need to watch this space as to how the Commission interprets it. So that's the first part. The second part is to do with solely as an investment or in the ordinary course of business. Now, these terms in some of the decisions such as New Moon, as well as Deepak and Zuari, have been sort of read in the same breath. And they are it is not entirely always clear through the CCI's decisions whether they are to be read conjunctively or disjunctively. Having said that, what is encouraging by looking at the explanation which was included to item 1 by the Commission, that they look at solely as an investment as a separate phrase, which would mean that they are to be read disjunctively. As a result, I think this is a very encouraging step. However, I'd like to make 1 or 2 remarks in relation to the exemption. The exemption actually provides that you could acquire less than 10%, provided you basically acted as an ordinary shareholder. You had no additional rights, and you did not have the ability through appointment of people on the board or influencing the management in any manner, the right to participate in the company. I think the question which has come to my mind a couple of times is the provision starts saying if all these conditions have been complied with, that shall be deemed to be solely as an investment. Now, are there, query, other situations where these conditions are not satisfied, but things could still be in the solely as an investment? For example, private equity. Private equity could treat, this is their normal line of business, they do it solely as an investment, and query whether there are those sort of clarities which can be provided as to whether this exemption works for them, even if there's perhaps, say, over 10%, but they had no participative rights. Do all the conditions always need to apply? The second sort of nuance that I wanted to discuss briefly, and that's the last point I will make before sort of handing over, is that in relation to, the ordinary course of business, there are certain decisions which have said that where you are acquiring a shareholding in a company which is in the same line of business or in a vertically related line of business, that would not be treated as being in the ordinary course of business. Whilst that makes perfect logical sense, that has a strategic flavor and color, the question really is, again, in the context of financial investments where, private equity or other financial investors do have a focus on a particular sector. They do because that's sort of where their domain knowledge in terms of research on that sector or what they have been tracking and following is, and whether multiple minority investments in the same sector are they then in the ordinary course of business, or can they fall within the solely as an investment bracket? And here, the interpretation being disjunctive is critical. So with that, I'll conclude.
Thank you, Shweta. Well, before I pass the mic on to Vaughan, the only point I would wish to make is that, the Commission has been passing its orders with quite clear explanation as to what is taken as control, why even below 10% with certain conditions you would need to file. And I think it's only a question of a period of time when more and more orders start coming out, because we must try and understand that not everything can come out in guidance notes or clarifications. Only the orders over a period of time would really start clarifying issues. And with less than 6 years in this, on the combination side, it probably will take some time. But yes, because the entire thing of 10% was probably added only in 2015. Earlier we were working without 10%. It could well have been that you still kept 25% as a line and said that anything below 25%, provided this is there, would not qualify for an exemption. But well, we decided to go in for 10% with for a particular reason. That has been explained in some of the orders. But then let's see how do we take it further. With this, I'll now pass it on to Johan, please.
Thank you. I'll just add a few things on the EU practitioner's perspective on whether acquisitions of a minority stake should be notified. I mean, as most of you know, the system at the European Commission level only catches transactions that give rise to a change of control. So an acquisition of a minority stake would only be notifiable if it gives rise to a change of control. We don't have a rule at least at the EU level, at the European Commission level, where there's a certain minority stake threshold that if you exceed that, a notification would be required. Just so, for completeness, there are some member states that have similar rules. I think Germany is probably the best known example. I think Austria and also Poland have somewhat different rules on what constitutes a concentration. And so in those countries, an acquisition of a minority stake that does not give you control could amount to a notifiable concentration. But at the EU level, it's only a concentration if you have a change of control. But the Commission has been consulting on this. It's launched a public consultation a little while ago now on whether it should change those rules. Should it have a system that's more, that could catch acquisitions of non-controlling minority stakes in certain circumstances. And I think right now that proposal has been parked, but there's been quite a lot of debate about this. Is this the right approach to only catch transactions that give rise to a change in control? Because I think, it's worth having that debate. There are some cases, I think, where the acquisition of a minority stake, even if it doesn't give you control, it does give you a certain influence that would be relevant in a competitive assessment, and in some cases could lead to anti-competitive effects that a regulator would want to review. There are, I think that's right in some cases. I think also everybody agrees that those cases are fairly rare, that typically if you don't acquire control, it's very rare for a deal like that to give rise to concerns. And so in determining whether that risk, the risk of sort of missing these few minority stake acquisitions, whether that risk is worth requiring that every minority stake acquisition over a certain threshold is notified. I think that's really sort of the balance that needs to be made. Is it worth the burden on acquirers of minority stakes to have to submit notifications in each case they acquire a non-controlling minority stake, just so that the few cases where issues might arise are caught or subject to a review? And I think you can't have that discussion without taking into account also what the burden is that lies on the notifying party, how much work is required in a notification, and are you talking about submitting a full notification, or is it something falling short of that? Could you, if you acquire a non-controlling minority stake, submit some kind of short form or even a brief notice? And that's something that the Commission, the European Commission, when it consulted on this proposal, that was one of the options that it put forward at the time, saying, well, we have, in Europe, we have a very burdensome notification form. And requiring a full Form CO notification, even in cases where a non-controlling minority stake is acquired, I think that'd be very far-reaching and would impose a significant burden or additional burden on companies that's maybe not justified. If it's a less far-reaching or a less significant burden where you say, well, you don't have to, if you acquire a non-controlling minority stake, you don't have to submit a full notification, but maybe something along the lines of a short notice of a few pages identifying the parties and this brief structure of the transaction and the sectors involved, and submitting that notice to the regulator, and it would then be up to the regulator to determine whether they want more information on that transaction or not. That kind of arrangement probably, or at least in my view, strikes a more equitable balance between, on the one hand, the regulator's desire to catch some of these acquisitions of non-controlling stakes, and on the other hand, the additional burden that you would impose on the notifying parties.
Oh, thank you, Johan. I, in fact, would fully on board with what you say, that we need to strike a balance. And yes, seeing how the cases have fared in the past, that out of 427 or 430 which have been approved till now, we didn't find AEC even in one. And the fact that the burden on the parties in terms of filing a full notification, yes, and I had said there are these costs to filing and the cost to time. So, well, if you have all these cases where you not found any AEC, for that far and wide one or two cases that really worth it that the commission needs to go in for a full form filing. Well, I think one is open to looking at this, but I am not the commission, but I can definitely assure the House that we are open to looking at these things. Now with this, let me come on to the second issue of what's been raised time and again on the issue of gun jumping. Now the Commission over the past years has, under Section 43A, penalized certain combinations, saying that on basis of gun jumping, and some of those cases have gone in appeal, and those appeals, I understand, have been accepted also. But the Commission, while deciding those cases and saying that gun jumping has been indulged in, had very clear reason for saying why under the Act. Now, but there still continue to be issues on this, and what I would now sort of invite Samir for his comments on how the companies and the firms in India view gun jumping, how have they viewed the Commission's orders on this, and then of course have Geert commenting as to how they looked upon in the European Union or other places outside. Thank you. Samir, could we have your comments on gun jumping, please?
Thank you. Thank you, sir. That's, I think, a fair summary. So just before we get into the various ramifications of gun jumping, perhaps just an additional word on gun jumping and the regime around it here in India, which is we have a suspensory regime, of course, which means it's a mandatory filing to the competition regulator 30 days after the trigger has occurred. And so to that extent, parties are required to make that filing within 30 days. And I'll tell you how that correlates with gun jumping, because invariably, gun jumping means that the Commission ought to have had a chance to look at the merger, proceed on that basis, and then give you its approval before you go ahead and consummate the terms of this transaction. And I think what filing parties find quite often here in India is if you have inherently a disincentive from going ahead and consummating that transaction, and there is a pretty heavy sanction for jumping the gun, as it were, is there really a need for you to also have a front-loaded 30-day requirement from the day of the trigger event? So you find yourself squeezed on both directions. So I think that's an ancillary conversation. So I'm not going to go down that line, but I think it's just useful to sketch out that that is in fact how our merger regulations work. And of course, the ostensible aim for a sanction against gun jumping is because competition authorities don't want to have to unscramble the egg after parties have gone ahead and given effect to the terms of a combination. That's what our Indian statute says. It says that thou shall not give effect to the terms of that combination. And that's where parties have had several discussions on what this actually means. I mean, what does it mean not to give effect to the terms of a transaction? After all, there are several steps that two merging parties might go through even before finally going through with that transaction. So say, for example, if you were to go through an integration committee or a planning committee where the two of you as merging parties said that we understand that the Indian authority is still reviewing our merger, but we would like to at least know that on the date on which that merger is agreed to, we should be able to consummate as quickly thereafter. So let's plan on the steps that we need to take after our merger is blessed. So a very clear idea that they will not merge or they will not give effect to the terms of the combination prior to clearance, but they would like to do so immediately thereafter, so they set up a planning committee. Now, is that giving effect to the terms of the combination under the plain statutory terms of the language? Equally, and I won't get into the Commission's decisional practice, but just to flag this, I think, as part of this discussion, is that in transactions where you have public market acquisitions, where a block of shares becomes available to you on the market, and where a transaction need not necessarily be a negotiated transaction. The transaction means you step in and you make an acquisition on the date, in a hostile situation potentially, on a date where those shares become available in a public market bid. In that situation, the Commission has, it's actually come up before the Commission, and the Commission has had to rule that the notifiable combination was actually the acquisition of those shares. And to the extent that you went ahead and acquired those shares without waiting for our approval is clearly tantamount to gun jumping. Now that leads to a bit of a systemic problem here, which is that if in hostile acquisitions of publicly listed companies, you are disallowed from actually making the acquisition of a block of shares which comes up on the market on day one, arguably we have as collectively sounded the death knell for public market hostile takeovers in India, because you will always need to calculate the possible risk of gun jumping. And an escrow mechanism where those shares cannot be voted on was also held to be not satisfactory, because the rules, in our current rules, do not allow for that. So I think going back to the overriding need for guidance from the Commission as to what parties can and cannot do in the process of the lead up to the consummation of the transaction, as well as on some systemic issues such as this, which is public market acquisitions, keeping in line with the Commission's objective of making this easier for parties upfront to have that guidance, fitting in with the overall view of the government, which is that merger control has to fit into the ease of doing business in India. I think that's where perhaps the discussion can be had on giving further guidance to parties. I don't think there can be an exhaustive list, but certainly if we knew where to start, it would be helpful. And perhaps the EC might be one place where we can look for answers.
Thank you, Samir. In fact, you have a point there in that particular case. Well, I wouldn't say anything beyond that, but definitely it makes good sense to be having greater discussion on these issues as to bring in some sort of a guidance. But then, like you yourself said, there cannot be an exhaustive list of what would constitute gun jumping, what would not constitute gun jumping. But yes, over a period of time, as things move on, probably greater and greater clarity on both the Commission's side and on the side of the requirement of the parties when to file would really come up. With this, I would request Geert now for his views on how they look at gun jumping in the European Union, please. Thank you.
Thank you very much. And first of all, thank you very much for inviting me to participate here. So on the issue of gun jumping, it's a difficult issue also from an EU perspective. It's an issue that for a very long time, actually, you didn't have decisions on gun jumping. There have been some more recently where indeed some fines have been imposed. But in terms of guidelines as to where is the line between what you can do and where you actually stray into an implementation of the transaction, which, as long as you don't have agreement from the Commission, you can't do. That guidance on where that line is not that clear. So what does that mean in practice? Obviously, in practice, mergers and transactions need to go ahead, which means that there needs to be some ability for parties work together towards that merger. And that question arises both at the stage of due diligence, where you must allow the parties to get to know enough of the other side to see whether or not they want to go ahead with the transaction. But knowing that at that stage, of course, you still are independent competitors and need to maintain on the market your position as independent competitors. So what can you do and not do within that context? The other context is indeed what Shamir referred to, is when the transaction has been agreed, is going ahead, has not been approved yet by the authority, but in the meantime, parties want to go ahead in terms of, I want to start preparing integration, etc. In terms of the first issue, there, the starting point is you need to remain competitors, so therefore, in terms of exchange of information, you need to be careful. There are, however, ways around that. In terms of a setting up of clean teams, for example, where you exchange information between people within the companies, but actually who do not have commercial functions, GC, CFO, but certainly not people who would set prices, for example. There, that's one way around it. Plus, and also that combined then with being very careful as to what information is it actually that you make available. And again, there are general rules and then general principles of information exchange. If you bear these in mind, so what can you exchange? Things that are in the past and do not have an influence anymore in terms of what actually is happening in the market, that would be fine. You can aggregate sometimes information and make it available in aggregated form, such that, that again, you don't really give too much away. Or you actually go to an exchange of more detailed information, but on an external counsel-to-counsel basis. And it's then to each of the external counsel to look at the information. They can then guide their clients in terms of how to look at things without making the information itself available. So there are, say, ways around that which are necessary, because, say, again, there's a balance to be struck here between, yes, absolutely, you need to maintain your role as independent competitors on the market as long as your transaction has not been agreed to, but you also need to be able to progress with the deal. Something similar in terms of that approach and principles you would try to apply once you have an agreement in terms of, yes, let's go ahead, but we don't have the fiat yet of the competition authorities in terms of, for example, integration. And again, there are things that you can set up in terms of how will we deal with issues of HR issues, how will we deal with issues of going out in the market after the deal has been approved and approach people. So discussions on a high level there, yes. What cannot happen is that you start implementing these, so that you start having discussions about actually going together to customers while the deal has not been approved yet by the authorities. There you risk straying over the line. What you can certainly not do is starting to have agreements, for example, in terms of, okay, once we have approval, let's set these kinds of prices on the market. Again, that would step over the line. So it is clear from what I said, it becomes very much a factual question as to what you can and cannot do. But I think the message here that I want to give is there are ways around that, because again, a balance needs to be struck between what your obligations are, what rightfully your obligations are on the competition law, to allow the authorities to look at the deal and making sure that, as Shamir said, they don't have to unscramble the egg if they were to come to a conclusion that actually they don't agree with the transaction as proposed, versus parties also being able to actually go ahead with that transaction. Then two very short comments on what Shamir said. First, his ancillary comment. In terms of a certain period of time after you have agreed to the transaction that you have to notify. The merger regulation in its original form had something similar. You had 7 days to notify. Very clear, it became very quickly clear that was in practice pretty much impossible. So the solution that had been around that at that time was basically what you had to do is basically write a letter to the Commission saying, that's what we have done, we know it's notifiable, we will in due time come to you with a notification, but just to let you know that, yes, absolutely, we know you have jurisdiction to review it. And then you had more time to actually prepare the notification. Interestingly, that, of course, while it was a practical solution around the problem, raises the question, what is actually then the use of having the 7-day notice period? And indeed, when the merger regulation was then reviewed, that 7-day notice period was dropped as an obligation. So now there is an obligation to notify, but in terms of timing, there is no obligation anymore. So that's the one question I had. And the second one was public markets. Public markets. So there, what the merger regulation has as a possibility is that you can, under certain circumstances, for example, when you have a public bid and where you have obligations once you have acquired a certain amount of shares, to launch a public bid and acquire these shares within a certain period of time, there it's possible to get a derogation from the Commission on the obligation not to close your transaction. But and there have been indeed cases where that derogation has been given. That derogation has been given on the understanding that while you acquire the shares, you will not exert the rights attached to the shares unless and until you get the approval. So the acquisition can go ahead, but not the actual performance of the rights attached to the shares.
Thank you, Gert. Well, in fact, I think the bottom deciding line should be that, well, you're absolutely right, that even before consummating, the parties probably would need to be discussing with each other so that no sooner it's consummated, you can put the combination of the merger into effect. But then what one really needs to be looking at, and I think that's what the Commission has been doing, is that have they been able, the discussions between them, are they influencing each other's working? And I think that's probably what we're looking at, that in case they are influencing each other's working, then definitely there's a case of gun jumping. But yes, it's a pure, simple discussion without any influence on each other, then definitely what you say makes a point. As far as public share purchases are concerned, well, the Commission also would look at, well, if it is one-off, putting the shares again into an escrow account, not a problem. But, well, if the Commission does find that it has been done quite strategically in the past, things had been happening in bits and pieces, then I think the Commission has taken a decision which is there as to what went into, what was the thinking and rationale or logic in the Commission's order. And I think at the end of the day, out of 427 odd cases, just about 10 odd 43 decisions in terms of penalizing is definitely not a bad performance. With this, thank you so much. I think the next area, of course, which is not of much, which has not been taken up with the Commission till now, but yes, has been in the minds of the parties and the firms, is appealing a merger decision. Who has the locus standi in terms of filing the appeal against a merger decision? Thank you. In fact, Rajshekhar will sort of get us through that now.
Good afternoon, everybody. The post-lunch sessions are usually the tougher ones because, it's easier to put you all to sleep. So let me start by trying to get you awake. That gray spot on the screen there is precisely the reason why I'm here. I appear for the Commission and against the Commission, so nothing I say can be in black and white. There have to be elements of gray. So today my baptism as a competition lawyer is complete. Till yesterday I was another litigator on Delhi roads. Sitting and addressing a panel or discussing at a panel on competition law completes this entire journey. Okay, I was also supposed to be, I thought I was going to be speaking at the enforcement panel. They said that thresholds had been crossed there and I was hived off to speak at this panel now. Now, these are probably what you are aware are the problems with merger control. An asset which thinks it's going to remain at the parent company decides to be sent along. And what are the consequences of that are things that lawyers continue to discuss and commissions debate. These decisions, of course, tend to impact many people. And given the fact that I think a majority of the discussions and the themes that emanated throughout the course of today appear to reflect, I guess, the constant pulls and pushes, particularly of a new competition jurisprudence. And we are tasked with a body which is required to promote competition. The stated object is, of course, to take away monopolies and promote competition, which is why we suddenly have the government also facing uncharted territories, where at one point in time in the pre-existing regime, public sector undertakings were exempt from competition law, as it were. And today, to a large extent, they're facing scrutiny, and they're really, really upset about it. It is in that context that this whole concept of locus standi becomes so much more relevant. And we've had a few instances in the recent past where this has come about. We have a statute. The problem with Indian legislative drafting is that we tend to borrow very freely from the past. And in the process, we pick up words and expressions which perhaps had a particular meaning at another time and place, but may not be most apt in a situation as in the current situation. But those again are the travails of the law, and as lawyers and as regulators, we work together to come and try and find a balance. The statute says any person aggrieved by an order of the Commission is entitled to appeal to the appellate tribunal. Of course, there are a set of orders that are appealable. And the question is it fair to exclude people who are individuals who seemingly have no real interest or stake in the overall outcome of that process? Do you see them as people who are really fronts for competitors? What if they raise credible issues which actually appear to have been glossed over because of the fact that the Commission was so busy looking at the entities in question that the overall effects of that transaction perhaps may have gotten left behind? And those are the problems perhaps that one looks at when one examines this issue of locus standi. A simple approach, of course, is, and I think the way the regulations are structured is to deal with it in that front. Parties are required to make a publication of the intent to enter into a transaction. The Commission has that time to scrutinize. And during that process, everybody under the sun has the ability to respond and put out their objections. I guess there are practical problems with that given the timelines involved and also the consequences of the timelines on the cost of doing business, that it is humanly impossible for a commission to scrutinize, say, 15,000 letters from various people. Some competitors, of course, you take them very seriously. But what about the stray instance of an academic who raises a very, very pertinent point? Now, if somebody has the ability to put that point to paper, does he get the right to address the commission at the stage when the commission is taking a view on the transaction? Or is it in the larger public interest to allow the transaction to be consummated under the overarching eyes of the regulator and give the system a mechanism to rectify a possible lacunae in the entire transaction process? I don't know, and this is something that the Commission really needs to consider, because the general practice one sees is that competitors rarely come to the forefront for a variety of reasons. And invariably you end up competitors' cases being argued by individuals. But at the end of the day, if the Commission does see that there is a credible stand, perhaps it is time to address that and give that opportunity at the stage when the transaction is being considered, so as to avoid the cost of a long regulatory process. We are already grappling with the larger issues of natural justice. We live in a strange, it's not strange, it's a unique system where natural justice is paramount. We've had a lot of debate on whether natural justice has to override the overall objective. I mean, the Commission sees itself as a regulator and not as a court, and says that I should not be tested on the basis on which courts and judicial decisions are tested. See us as a regulator and look at the broader picture. So from that perspective, we have a few instances in the recent past where the Commission has chosen not to interfere or not to accede to requests by third parties to interfere in the process of a transaction. Having said that, they've also reached out to what the Commission in its wisdom believed were people who would be affected directly by the transaction. And if there was no credible competition concern raised by competitors or parties in the industry, then the Commission has stayed its hands. I think the Commission perhaps could help in the process if certain guidelines are framed to assist the people who are evaluating the transactions internally before the Commission ultimately looks at it, number one. Number two, of course, in the context of how does the Commission address these issues before the Competition Appellate Tribunal? Does it take an adversarial stand where somebody stands up and says, I'm a complete third party, I'm a stranger to the transaction, but I'd like to challenge the Commission's position? And should at that point in time the Commission say, we speak through our orders, and our orders speak for themselves. We've taken a view on the decision. Perhaps this gentleman was before us, he wasn't before us. If he was before us, what are the reasons that we ascribe to whether we've considered it, haven't considered it, or did we have an overall public interest in question? And we've crossed that threshold in our mind. We've satisfied the need, the principal objective and our obligation to examine the transaction and the effects of the transaction on the overall economy, etc. And therefore, we need say no further. If from a judicial review perspective, the tribunal were to take a view, then of course the Commission has recourse to an appellate remedy, if it were. I guess the point I'm making is, having taken a decision on a transaction, should the Commission consider as a part of its regulatory strategy and more importantly its litigative strategy, staying somewhat aloof of one rung of the litigative process and letting that review take place on the record itself, and then consider whether in a given case the Commission takes matters forward.
Thank you, Rajshekhar. In fact, let me just clarify here that the Commission, I think, has always been quite open in terms of any third party asking for information, also wanting to join in. But yes, once the Commission has decided a certain case and passed its order, then the matter as per the Act stands closed, and I don't think the Commission can go back and reopen the issue. And of course, it's open to the person to move to the compact in terms of appealing the order of the Commission. Now, even prior to publication, and where the parties have been required to give a public notice, you may have noticed that earlier there was no provision of a small summary of, we now started asking for a small summary of 500 words. Earlier, the parties were required to give a 2,000 word summary for use of the Commission. But then I think last year we decided that in addition to the 2,000 word summary, we would also need a 500 word summary, which the day the notice is filed, shortly thereafter we put it in the public, on the Commission website, in the public domain, precisely for this reason, that the party, any third party is aware right from day one as to what are the cases which have come before the Commission. So that at any stage, rather than towards the end, when the published notice has been issued, the parties come to know at that point of time. What the Commission feels is that the public at large needs to be aware at day one itself as to what has been filed before the Commission. The Commission has also decided that in case a third party seeks certain information, and if the third party has been able to, it's not a party to the combination, but yes, as a third party, as an interested party who does get affected, we would make the information available. And I think it's happened in one case till now, where I think the Commission did decide to make the information available, but then probably the party wanted to have inspection of the records, which the Commission felt that, well, that was not permissible. Now, the Commission, of course, would be quite open to sort of discussing this, but then, like I said right at the very beginning, that once an order has been passed, the Act is very clear, you can't, on the basis of information coming thereafter by any third party, reopen the issue. Thank you. In fact, I would request either Geert or Johan that how do they look at these things in the European Union once an order on combination merger has been filed, and any third party wants the authority to look into it, to review its decision, how is it dealt with outside? Thank you.
So yeah, from a competition perspective, and it's of course it's that balance also that you need to strike. So the way the Commission tries to do that is a bit similar to what I understand you actually now doing. So as part of your notification, you have to provide a very short summary of what the transaction is about, which is then published in the official journal for us. And that allows any third party to provide comments within a certain period of time. So that's how, the public at large, if you want to, is alerted to the fact that there is a transaction, that if they have comments, that they can provide comments. And then, of course, during the investigation itself, there are other ways of getting information from people who are more directly involved, either as suppliers, competitors, or customers, through information requests that the Commission will send out. And that, of course, is another way for the Commission to make sure that the information is obtained from the relevant parties. And then maybe a last comment, and it goes to, is you being active in that procedure enough to give you standing? That question arises in a merger context for the Commission in a second phase. So if you go to an in-depth investigation and the Commission adopts an SO, after the adoption of the SO and a written response to the SO, the parties to the transaction may ask for an oral hearing, so the possibility to present their case orally before the Commission. It's a right of the parties. They don't have to take it, and therefore if they don't take it, it doesn't take place. But if they do take it, then the question arises, okay, for third parties, can they also attend? And what they have to prove is that indeed they have some interest in doing so. There is a function that is an independent function in the Commission, which is called the hearing officer, who will decide whether or not indeed you have standing to participate in an oral hearing.
Thank you, Gert. In fact, there's this issue of confidentiality also that the Commission sort of looks at while examining such requests. But in fact, Rajshekhar had two very specific issues. One is that once you have decided the case, do you, on the application of the third party, reopen it to review? And secondly, if there's an appeal against the order, what is the position taken by the competition authority which has approved that commission? Do you oppose that, or are you in fact there are any issues? What happens actually?
So on your first question, would the Commission itself reopen? No, I don't see that happening. So as long as they have gone through the process and people have been allowed to provide comments through the publication in the official journal, so they could, and other parties will actually have been more closely involved through through questionnaires, etc. Once the Commission has received all that information, has looked at it and come to a decision, that is then the Commission decision. That can then be challenged in front of the court in Luxembourg. And the court in Luxembourg has itself strict rules actually in terms of locus standi, which are not that easy to meet. And it's actually then up to the court who will decide whether third parties indeed meet that interest test of locus standi.
Thank you so much, Gert. In fact, to the before we take on the questions, the final area of discussion, which of course has been a major area of concern with the parties and the firms, is that in terms of a de minimis exemption, do you look at an enterprise or the business division of the enterprise? Could I now request Shweta for views, and thereafter Gert, please?
Thank you, sir. I think the issue, as Sir rightly points out, comes up largely in the context of the applicability of the de minimis exemption. And that is in the context of asset or business sales, where that which is being transferred is a subset of a larger enterprise, but not separately incorporated as a legal entity. And the question is, in determining whether the thresholds are met or not met, what is it that one must look at? On the one hand, there is the argument that, it is Section 5 starts with the words, the acquisition of an enterprise, and then goes on to saying, through the acquisition of its assets, shares, voting rights, or control. And therefore, the fundamental question really is it that you must acquire an enterprise, and the various modes are just methods of how you can acquire the enterprise. And if that is the case, whether the enterprise is something which is less than a legal entity, or is it itself a legal entity. The definition of enterprise actually sort of adds a layer on top of this, which is that it talks about, it is inclusive. It talks about certain types of, artificial juridical persons. And then it talks about, the last is a catch-all, or saying any other artificial juridical person. And whether the business undertaking which is being transferred, or the sort of set of assets which are being transferred as a part of a transaction, should have the color of an enterprise that can operate on the market for conducting its business. And if that is the case, then the assets and turnover thresholds perhaps should be looking at that which is being transferred, the undertaking or the business division. And one set of logic would dictate that one should look at application of the thresholds to the enterprise, and the enterprise should be read down to as the business which is being transferred. However, the other argument on the other side is that the enterprise talks about an artificial juridical person, and whether an undertaking can be tantamount to an artificial juridical person, since it cannot sue and be sued in its own name. And that being the case, the application of the thresholds is to the entire seller. Now, this, in the context of the target exemption, becomes particularly problematic for conglomerates, because you may be selling one small division which, say, has a turnover of 20 crores, no assets in India, but there are other assets and turnover of the business as a whole, the conglomerate entity as a whole, which trip up the assets and turnover thresholds under the Competition Act and the de minimis exemption. And the question really becomes one of whether the competitive effects of a small division with such minor turnovers or assets would outweigh the requirement to notify. So as in, what I'm trying to say is that, does it make more sense to notify transactions even though the competitive effects are arguably minor? So this is an area where, clarity can either emerge through some sort of creative interpretation, either by the COMPAT or by, this thing, since the Commission has made its position quite clear, that they will be looking at the seller